Hello lovely YouTube family, welcome back to Tech and Vision. In today's video, we're going to talk about the US court claims about the release of the redacted versions of Jeff Bezos' lawsuits against NASA and SpaceX. Before we start, I would want you to hit that red subscribe button to avoid missing any amazing video from us. A redacted versions of Jeff Bezos' Blue Origin lawsuit against NASA over the lucrative lunar lander contract given to Elon Musk's SpaceX earlier this year was disclosed by the United States Federal Court of Claims on Wednesday. Historically, a staunch advocate for prioritizing safety, NASA inexplicably disregarded key flight safety requirements for only SpaceX in order to select and make award to SpaceX proposal that assessed as tremendously high risk and immensely complex, even before the waiver of safety requirements, Blue Origin said in a lawsuit filed in August. Blue Origin filed its lawsuits after the U.S. Government Accountability Office rejected the company's objections and upheld NASA's decisions. The decisions of the congressional watchdog validated NASA's surprising announcement in April that it had awarded SpaceX a $2.9 billion lunar lander contract. SpaceX was in a competition with the Blue Origin and Dynetics for 2 contracts, but NASA only awarded one due to a lower than expected budget allocations for the program from Congress. Blue Origin is attempting to reverse NASA's decisions to grant SpaceX a lunar lander contract, claiming that SpaceX proposal failed to meet review requirements, rendering it unawardable. The United States Court of Federal Claims revealed a heavily redacted versions of Blue Origin's complaint filed with the court on August 13 on September 22nd. The case is essentially an appeal of the company's objections to SpaceX award of the human landing systems, which the Government Accountability Office rejected on July 30th. Blue Origin's main claim is that NASA disregarded a requirement that bidders conduct a flight readiness review before launching each component of the lander systems. Blue Origin claims that before each tanker Starship's launch, which carried propellant to fuel the lander Starships, SpaceX failed to include FRR. NASA did require a FRR before each type of launch in later negotiations with SpaceX, but Blue Origin claims that this too failed to meet the solicitation standards. Failure to meet that requirement was a deficiency that Blue Origin argues should have been disqualified SpaceX from an HLS award. The agency's decisions to select SpaceX deficient proposal for initial conditional award was irrational and indirect violations of the solicitation's ground rules, stating of errors are hereby notified that proposals evaluated as having one or more deficiencies unawardable. It stated in the complaint, "We stand by our positions that NASA selected a proposal that was not in compliance with the solicitations. There are serious safety issues around that, and that the waiver of material requirements prejudiced us and Dynetics," Megan Mitchell, Vice President of Government Relations at Blue Origin, said in an interview. The GAO concluded that NASA erred in not mandating a FRR before every launch of lander element in the public versions of its conclusions on the Blue Origin and Dynetic bid protest, released August 10. The protests were not upheld because there was no indications that the businesses could or would have revised their proposals to materially boost their likelihood of getting the award if they had learned about the relaxations of the FRR requirement. Blue Origin disregard. Had Blue Origin known the agency would waive the FRR requirements and other requirements that greatly impact schedule and risk, Blue Origin would have engineered and proposed an entirely different architecture with corresponding differences in technical, management, and price ratings, it claims. It does not elaborate on what architecture would have been, although the passage that follows in the document is redacted. NASA, following talks with SpaceX, which include fixing the FRR issues, were also criticized in the complaint. The government referred to it as post-selection negotiations, but Blue Origin contends that the negotiations should be classified as discussions under federal acquisitions rules, requiring NASA to undertake equivalent discussions with the other bidders, allowing them to amend their plans as well. Had the agency held discussions with Blue Origin and revealed its funding limitations to Blue Origins as it did with SpaceX, Blue Origin would have lowered its price to meet those funding limitations, the company states in the complaint. Blue Origin also would have enhanced its technical and management proposal and modified its payment schedule to fix purported advance payments. SpaceX did not respond to a request for comment on the issues raised in the complaint, but in a tweet, SpaceX chief executive Elon Musk rejected the claims about FRRs. "We always do flight readiness reviews. This argument makes no sense. Many of the details in the complaint are redacted. In one case, Blue Origin appears to suggest another deficiency in SpaceX proposals. In addition to SpaceX failures to meet solicitations requirement for FRRs, SpaceX also failed. But most of the rest of the paragraph that follows is redacted until the final sentence. NASA completely overlooked this error and did not assess SpaceX any weaknesses for failure to meet this requirement. Blue Origin was frustrated by the redactions procedure since it had planned to have a version of their complaint disclosed by the late August. Mitchell stated in an interview before the redacted versions was released, "The other parties of the case are redacting significant portions of our fillings. In order to ensure that the records are not over-redacted, the company's lawyer were working with the court." Work on NASA's award to SpaceX has been halted in the Blue Origin's lawsuit until the end of October as a part of an agreement between the suit's party for a speedy review of the matter. In its case, Blue Origin requested that the court halt further work on SpaceX awards, order NASA to restart conversations with all bidders and make a fresh selections and reimburse Blue Origin's legal fee. In addition to the lawsuit, Mitchell stated that the Blue Origin is still lobbying Congress for more funding so that NASA can make a second HLS award. That financing was not included in either the House's routine yearly appropriation bills or its versions of a $3.5 trillion budget reconciliations package, but she expressed hope that Senate versions of both legislations would contain more HLS funding. "There are a lot of irons in the fires for us." Blue Origin, based in Kent, Washington, and the other 4 companies will be tasked with developing lander design concepts and evaluating what it will take to make them into viable systems over the following 15 months. They'll also test components and create technology to help future landers avoid problems. Blue Origin would get $25.6 million in milestone payments, Lockheed Martin $35.2 million, Northrop Grumman $34.8 million, Dynetics $40.8 million, and SpaceX $9.4 million. The unredacted versions of Blue Origin's complaint, according to SpaceX, should be kept secret since it would reveal SpaceX proprietary and sensitive information. On these subjects of redactions, the judge in the case, Richard Hertling, sided with SpaceX. The court is scheduled to hear oral arguments in October, with the decisions expected in early November. Meanwhile, NASA has awarded Blue Origin, SpaceX, Dynetics, Lockheed Martin, and Northrop Grumman a total of $146 million in fixed-price grants as a part of a follow-up initiative targeted at improving the space agency's lunar landing capabilities. Blue Origin has previously protested that Appendix N and the subsequent request known as Lunar Explorations Transportation Service, or LETS, are underfunded, ambiguous, and would replicate the substantial work done under Appendix H. NASA Administrator Bill Nelson referred to the case when asked in a September 21st call with reporter about the ability to meet the goal of returning humans to the moon by 2024 on the Artemis 3 mission. "If you have a coin, you can flip it as to what's going to happen in the legal wrangling that's going on right now," he said. "What is the federal judge going to decide? When is he going to decide? What are the further legal possibilities about that? Once we know better about things like that, then we can answer on Artemis 3. That's all for today. Share your thoughts with us in the comment. I hope you liked the video. If you did, make sure you hit that like button and subscribe to the channel so that you never miss any amazing video from us.